Anything from the state of defense before we bring the jury in?
No, sir.
Judge, can we approach briefly?
Sure.
I'm a little confused. What are you concerned about? Because I will give them the instruction of discharge. I have to leave it up to them whether they speak to someone or not. So what would be
My concern is that I don't know if the reports are accurate or not, because I haven't heard of it myself. But there are jurors saying that some other jurors had already made up their mind or had some discussions or things of that nature. So if there's anything potential that we find out in between now and, I'd just like a little bit of time to flush that out and make sure we can issues with potential juror misconduct that was going on that we weren't aware of until that interview.
Well, I'm trying to figure out what it is you're asking me to do right now.
Well, I'm just putting it on the record and warning the court that in the event the verdict comes back guilty, that we would be asking for some time to be able to just flush out those issues and file anything that may be appropriate before any potential sentencing if there was.
Go ahead.
I think that's all speculative. I don't think that's all legal reason to delay sentencing.
Thank you. Thank you. I'll let you put that on the record.
Let's bring the jury in.
Yes.
All rise, jurors in courtroom.
And everyone can be seated. And who is our foreperson? That would be Mr. Charles Madison, is that correct, sir?
Yes, sir.
Okay, sir, has the jury reached a verdict?
Yes, sir.
Would you please hand that verdict to the bailiff? Okay, court has reviewed the verdict form, finds it in order. I'm going to hand this to the clerk of the court. I'll direct first that the clerk review the verdict form and advise the bench whether he finds it in order. Following that, I'll direct you to post the verdict. Ms. Schenecker and counsel, you please rise.
Yes, sir. I reviewed the verdict form. I find it in order, Judge.
Post the verdict.
State of Florida versus Julie Schenecker, case 11 CF 001376, trial division 3. We, the jury, find as follows to count one of the charge. The defendant is guilty of first-degree murder. The defendant did actually possess and discharge a firearm causing death. We, the jury, find as follows as count 2 of the charge. The defendant is guilty of first-degree murder. The defendant did actually possess and discharge a firearm causing death. So say we all, dated this 15-day May 2014, Charles Madison, foreperson of the jury.
And Mr. Madison, sir, is that indeed the jury's verdict?
Yes, sir.
Do counsel wish to have the jury polled?
Yes, Your Honor.
Clerk will now poll the jury.
Sherry Kendall, is this your verdict?
Yes, sir.
Charles Madison, is this your verdict?
Yes, sir.
Trent Lawhon, is this your verdict?
Yes, sir.
Tina Ocampo, is this your verdict?
Yes, sir.
Mario Thomas, is this your verdict?
Yes.
Donna Williams, is this your verdict?
Yes, sir.
Ricky Ramos, is this your verdict?
Yes, sir.
John Hart, is this your verdict?
Yes, sir.
Julian Sykes, is this your verdict?
Yes, sir.
Barbara Hawkins, is this your verdict?
Yes, sir.
William Cheslowitz, is this your verdict?
Yes, sir.
And James Hall, is this your verdict?
Yes.
Okay, thank you. You may be seated. Anything from the state or defense before I give discharge instructions to our jury?
No, Your Honor.
No, sir. All right. And with that, members of the jury, ladies and gentlemen, I wish to thank you for your time and consideration of this case. I'm going to advise you of some very special privileges that are enjoyed by jurors. That is, no juror can ever be required to talk about your discussions that occurred in the jury room, except, of course, by court order. And before anyone gets a court order, they have to come before court just like this, file a petition or a motion, have a hearing on that to obtain such an order. For centuries, our society has relied upon juries just like you for consideration of difficult cases. We've recognized for those hundreds of years that your deliberations, your discussions, and your votes should remain your private affair as long as you wish it. So the law gives you that unique privilege not to speak about the jury's work. Now, there's another side of that coin. Just as you're at liberty to refuse to speak to anyone, all the admonitions I've given you throughout this proceeding, of course, no longer apply. So just as you're at liberty to refuse to speak to anyone, you're now similarly at liberty to speak with anyone about your deliberations. Just remember, a request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from attorneys, or elsewhere. In the end, it's up to you to decide whether to preserve your privacy as a juror. I'll take a moment, as I did with the alternate jurors, and thank you for your attention and patience over the last almost 3 weeks. It's absolutely true. If we didn't have citizens who come forward and leave work and home and all those obligations as you have, and what I always refer to as honest fulfillment of jury service, if we didn't have citizens who did that, we wouldn't have the system of justice we do. It depends upon you. I want to thank you for your service, and now I can say those other words I know that are important at this point. You are now discharged.
All rise. Ladies and gentlemen, please get your electronic devices. Ladies and gentlemen, we go back to
Okay, our jury's exiting the courtroom. Ms. Schenecker and counsel, if you'll remain standing, everyone else can be seated. Schenecker, in case number 11 CF 001376, after jury trial, you have been found guilty as to count 1 of the charge, and in that case, guilty of first-degree murder. The jury specifically finding that you did actually possess and discharge a firearm causing death. As to count 2, you have similarly been found guilty of first-degree murder. The jury finding as to that count as well that you did actually possess and discharge a firearm causing death. I will now judge you guilty of those offenses to which you were found guilty. I'm going to direct the clerk to record the verdict, and I'll simply turn to counsel and ask if there's any lawful reason we shouldn't proceed with sentencing.
Judge, based on the issues that I've presented to the court, and I would just like an opportunity to file any post-verdict motions. So I'd ask for a short delay of a week or 2 in order to ensure that those matters are heard before sentencing.
I don't find any such reasons for delay to be justified or legal.
Counsel, whether I proceed to sentencing now or whether I don't. It doesn't change your ability to file any appropriate motions based upon what you indicated at the bench. So for that reason, I'm not prepared to delay sentencing under the circumstances. So, anything else?
No, Your Honor.
All right, well, then I guess we're prepared to proceed to sentencing. And you want a few minutes? Otherwise, I'm prepared to hear from counsel.
Yes, Your Honor, if I have a few minutes.
All right, how long do you need? I'll step off and give you the time, because I'm going to hear whatever both sides wish to present on the record as we proceed.
Yes, sir.
I'll step off. Let me know when you're ready.